Courts all across India have shocked people with their ruling when it comes to gender inequality issues. Just like the members of any other profession, judges too live in the society and they can never be truly free of the biases, prejudices and the flaws that are seen in the society from which they are coming. But still, as those in charge of dispensing justice, they are expected to conform to a higher standard than those in other professions, including politicians. But many of them struggle to do that, particularly in the lower rungs of the judiciary. There are several instances where judges have displayed a lack of sensitivity when it comes to dealing with vulnerable sections and victims. For example, a judge in Gujarat High Court recently told a minor rape survivor who was looking for termination of pregnancy that she should read Manusmriti and that the girls in the past would get married aged 14 or 15. In another case, a court in Kerala reached the conclusion that the decision of a mother to leave her family and live with someone else was motivated by pleasure and that her so-called wayward life would affect her children. Interestingly, the Kerala High Court had called these comments distasteful. In a third case, a Karnataka High Court judge said that it was unbecoming of Indian women to go to sleep after being raped, and then the judge granted anticipatory bail to the accused. These are a few instances where courts have reminded us that the judiciary is also an extension of the sexist society that we live in. Even where the mischaracterization is not as apparent, judges can often end up describing women as Sita, Lakshmi, Saraswati and other Hindu goddesses. But often this is done with the implication that women must be as tolerant, forgiving and sympathetic as these goddesses, in turn holding them to a standard that men are never subjected to. This is often a reflection of the social construct that women's primary role is that of nurturing and enduring pain. Well, the problem is not one with easy solutions. The Supreme Court is making a start with a handbook on gender stereotyping. For example, is it okay to say the word affair? What about the phrase biological sex or eve teasing? The Chief Justice of India, Justice Chandrachud, himself has written the foreword for the handbook, and he says that the book aims to assist judges and the legal community in identifying, understanding and combating stereotypes about women. Then the handbook goes on to discuss the idea of stereotyping, its impacts, the alternative language that can be used, the reasoning pattern behind such stereotype and how they are wrong. The book also highlights different Supreme Court decisions that have rejected such stereotypes. We have a table that presents us with a vocabulary that is against gender stereotypes. It points out that the word affair promotes a stereotype and the alternative language that can be used is relationship outside of marriage. The alternative for biological sex is sex assigned at birth. We are asked to use child who has been trafficked instead of child prostitute, street sexual harassment instead of eve teasing, rape instead of forcible rape. The handbook has a set of such words. The book then talks about understanding stereotypes. It says that a reliance on stereotype is often subconscious and that stereotypes prevent us from viewing an individual before us as a unique person with their own characteristics. To make it clearer, the handbook gives us some anecdotes. It says, even when a male and female employee are of the same designation, a female employee may be tasked with administrative duties such as organizing office events or buying stationery, while male employees are exempted from such tasks. It says that there is a stereotype that individuals from oppressed castes are not as accomplished in school or university in comparison to individuals from oppressor castes. And then we see how such stereotypes affect judicial decision making. The handbook says that if a judge gives in to such stereotype that people from low income background are likely to commit more crimes, his decision will be wrong. Similarly, if a judge believes the stereotype that women lie about being sexually assaulted, he might discard a sexual assault survivor's testimony, which becomes an act of injustice. The handbook divides gender stereotypes into three categories. First one is stereotypes based on the so-called inherent characteristics of women. Second, stereotypes based on the gender roles of women. And third, stereotypes related to sex, sexuality and sexual violence. Stereotypical ideas like women are overly emotional, women are weaker, women are warm, women of oppressed or marginalized communities have diminished cognitive capabilities or a limited understanding of the world are challenged in the handbook. Against such ideas, the reality of the conditions are given, which say that gender doesn't determine capacity for rational thought. A person's strength is not dependent on their gender, and community and individual belongs is not determinative of their cognitive capabilities. The second part, dealing with gender roles of women, says that people of all genders are equally suited to the task of caring for others. People of all genders are equally capable of doing house chores. Women who are homemakers perform unpaid domestic labor. The most important part of the handbook is where it challenges the stereotypes related to sexual violence. The book notes women are often forced to interact with the men who have sexually assaulted or raped them, and women may register a complaint after a lapse of some time when she thinks she is able to, as opposed to the ideas that if a woman speaks or interacts normally with the accused, her complaint of sexual assault or rape is false, and if a woman complains after a long time, they are lying. It also dismisses the idea that dominant caste men do not want to engage in sexual relations with women from oppressed castes, and says that dominant caste men have historically used sexual violence as a tool to reinforce and maintain caste hierarchies. And Banwari Devi's case is cited as an example. The book also highlights how it is possible for a man to rape a sex worker, and it notes women who say no mean no and there exists no further ambiguity. Women who wish to welcome sexual advances will communicate their consent using clear language such as the word yes. It also notes that transgender individuals are one of the groups which are most vulnerable to sexual violence. Finally, the book gives an account of cases where gender stereotypes were rejected. It mentions the Joseph Shine vs. Union of India case, in which a constitution bench of the Supreme Court struck down the offence of adultery. It also mentions the state of Jharkhand vs. Shailendra Kumar Roy, in which the Supreme Court reiterated its categorical ban on the two-finger test. It cites the state of Punjab vs. Gurmeet Singh case, in which the Supreme Court evaluated the testimony of a survivor after a trial court had refused to accept the victim's testimony. It also cites the state of Uttar Pradesh vs. Chotelal to uphold the absence of physical injuries must be evaluated contextually. It cites the state of Punjab vs. Gurmeet Singh case again to say that delay in filing an FIR or complaint cannot be mechanically used to create doubt. And to conclude, the handbook says that even though this specific book is on stereotypes about women, the judges must be vigilant against all forms of gender biases and ensure that every person, regardless of their gender identity, is treated equally and with dignity before the law.